When police tell you to stop filming, that moment isn't about your phone. It's about your rights. One wrong move, one emotional reaction, and you could lose both your footage and your freedom. In this video, I'll explain exactly what to say, how to act, and why it works, legally and physically. Know your rights and control your body. If an officer ever tells you to stop filming, remember this. That moment is not about your phone. It's about your rights and whether you understand how to enforce them without escalating the situation. You need to know the law, the limits of police authority, and the psychology of how officers perceive control. Because the truth is, when a cop tells you to stop recording, it's rarely about safety. It's about power. And if you don't know the right words and posture to use, you can lose both your footage and your freedom in seconds. Let's start with the conflict. You're filming a traffic stop or maybe an arrest in public. You're standing back, you're not interfering, and suddenly the officer looks your way. Put the phone down. Maybe they say it softer. Stop recording, sir, or more aggressive. Turn that camera off right now. The tone doesn't matter, the intent is the same. They want compliance and your instinct might be fear. Your heart rate spikes, adrenaline floods your bloodstream, your prefrontal cortex, the rational decision-making center, starts to shut down and the amygdala takes over. You go into fight, flight, or freeze. That's the body's automatic reaction under perceived threat. Understanding this physiological process is crucial because if you let the body lead before the mind, you risk saying something reactive, something that could later be used against you. Now here's the law. You have a First Amendment right to record public officials, including law enforcement, performing their duties in public spaces. This has been reaffirmed in multiple federal circuits, like Glick v. Cuniff, 2011, and Turner v. Driver, 2017, which recognize that filming the police is a form of free speech and public oversight. But that right is not unlimited. It's subject to what's called reasonable time, place, and manner restrictions. That means you can record as long as you're not obstructing, interfering, or jeopardizing safety. The gray area lies in how interference is interpreted. So when an officer says, "Stop filming," the problem is not whether you can record, it's whether the officer believes you're interfering. That distinction is everything, because in practice, cops often claim interference as a catch-all justification for shutting down recordings. Here's the first tip. Never argue about your rights in the heat of the moment. Assert them clearly, then disengage verbally. Here's why. Conflict heightens an officer's sympathetic nervous system response, the same biological stress reaction that floods them with adrenaline. Their perception narrows, their auditory processing decreases, and they become hyper-focused on perceived threats. If you respond emotionally, you're reinforcing that threat signal. The result? Escalation. But if you speak with measured calm, you trigger the opposite response. Their parasympathetic system slowly reactivates, lowering tension. That's not psychology theory, it's physiology in real time. So your script is simple. If told to stop filming, say, "Officer, I'm not interfering. I'm exercising my First Amendment right to record from a safe distance." Then take one step back, not sideways, not forward, back. That single step signals non-aggression while visually reinforcing distance. Keep your voice low, your hands visible, and your camera steady. You're not just asserting your rights, you're documenting that you did everything right. The solution works because it combines law with behavioral science. You're protecting yourself both legally and physically by staying calm, invoking constitutional language, and showing compliance with spatial awareness. This reduces perceived threat while preserving the legal record you need if things escalate. Second tip, keep filming, but reposition if ordered. The key word in stop filming orders is proximity. If you're within 10 to 15 feet, some jurisdictions allow officers to claim interference. But move back and stop filming are not the same. If they tell you to move, comply with that distance, but keep recording. Verbalize it on camera. "I'm complying with your order to move back," and continuing to record for transparency. This single sentence transforms your footage into evidence that you obeyed lawful orders while maintaining your rights. Here's why that's powerful. Courts weigh officer credibility against objective evidence. Without footage, it's your word against theirs. With footage, it's about time-stamped truth. The moment you narrate your compliance, you're creating a chain of factual integrity. You're demonstrating reasonableness, a term courts use often when assessing police-citizen encounters. Reasonableness is your armor in civil litigation and in criminal defense alike. Third tip, understand when police can legally restrict recording. There are 3 lawful justifications they might use. 1, if you're in a restricted area, crime scene perimeters, private property under warrant, or a cordoned-off zone. 2, if you're physically obstructing or causing distraction that could endanger officers or suspects. 3, if you're under lawful arrest or detention yourself. Outside of these, orders to stop recording generally lack legal merit. Now, some officers will rely on the ambiguity of the phrase lawful order. It sounds official, but not every order given by police is lawful. A lawful order must be based on a legitimate government interest, such as safety, investigation, or order preservation, and must be narrowly tailored to achieve that goal. So, step back 5 feet for safety is lawful. Delete that footage or turn off your phone is not. Deleting or demanding deletion of footage can itself constitute a violation of your constitutional rights. If that happens, say clearly, "I will not delete evidence." If there's an issue, I'm happy to speak with your supervisor. Let's talk body control. Your composure is your defense mechanism. When adrenaline spikes, the vagus nerve, your main parasympathetic regulator, can help counteract panic if you control your breathing. Slow inhales through the nose, steady exhales through the mouth, maintaining eye contact without defiance. Your posture should communicate cooperation without submission. Shoulders relaxed, phone chest level, elbows anchored. You're not hiding the camera and you're not aiming it like a weapon. Visual neutrality keeps you safe because perception dictates reaction. Officers read body language faster than they process speech. 4th tip, do not physically resist phone confiscation. If an officer grabs your phone, say immediately, "I do not consent to a search or seizure." That phrase triggers 4th Amendment protections and builds a clear record for your attorney. If they proceed anyway, let them. Physical resistance turns a constitutional violation into a resisting arrest charge. The legal principle is comply now, contest later. The moment you state non-consent on camera, your attorney gains leverage to challenge the seizure as unlawful under Riley v. California, 2014, where the Supreme Court held that phones require a warrant to search. Understand the biology behind why compliance in this moment is strategic, not submissive. Your amygdala tells you to react when you perceive unfairness or threat, but your prefrontal cortex must override that impulse to preserve long-term safety. Legal defense is not won through emotion, it's won through evidence. The video you take, even if temporarily seized, may later prove misconduct or vindicate you entirely. 5th tip, if police order everyone to stop filming, don't argue constitutional theory on the street. This happens most often during tense scenes, protests, use of force incidents, or chaotic arrests. Officers may yell, "Everyone stop recording," under the pretext of controlling the crowd. You do not need to obey that order if you're not interfering, but your response must remain strategic. Don't yell, "I have rights." Say calmly, "Officer, I'm recording for transparency. I'll stay back." Then move visibly farther away and keep filming. Your movement demonstrates compliance while your continued recording maintains oversight. That's how you assert rights without confrontation. This works because it aligns with de-escalation physiology. Movement relieves visual tension in the officer's field of focus. When you back away, their optic and motor systems perceive reduced threat proximity. You're triggering a subconscious release of adrenaline in their body, calming the moment. This is why calm assertiveness outperforms verbal confrontation every single time. 6th tip, always document distance and behavior. Narrate where you are. "I'm standing about 20 feet away. I'm not interfering." These statements anchor your footage in factual context. Later, if the footage becomes evidence, prosecutors, defense attorneys, and judges will use that context to assess reasonableness. Your words become metadata for truth. This principle is tactical law. You're narrating your compliance in real time to build an indisputable record. You're not performing for social media, you're building a factual shield. Lawyers love clean evidence. Timestamps, clear angles, calm narration. That's the trifecta that wins cases. 7th tip, if officers claim you're violating privacy laws, know the distinction. Some states have two-party consent laws for recording private conversations, but police interactions in public are not private. Courts have consistently ruled that officers performing public duties have no reasonable expectation of privacy. That's why you can record them. However, using that footage for harassment or commercial gain without consent may violate separate laws. So, while you can record freely, always use footage responsibly, especially if you post it online. Editing or framing that footage to mislead can open you to defamation or interference claims. So, the problem, officers may falsely assert privacy law. The solution, calmly correct or move on. The reason it works, you're demonstrating superior legal literacy and composure, not argument. 8th tip, if multiple officers surround you, use your phone's live upload or streaming feature. Apps like Facebook Live, YouTube Live, or independent recording apps with cloud backups turn your phone into a witness that cannot be silenced. If the footage is uploaded instantly, even if your phone is seized or destroyed, your evidence survives. That's constitutional self-defense through technology. Just announce it out loud. "I'm live streaming this for my protection." That statement alone changes the dynamic. Officers know the footage is already public. It moderates their behavior. The legal reasoning is simple. Once your feed is public, any interference becomes a First Amendment violation with clear damages. The 9th tip, after any confrontation, write a contemporaneous account. Memory decays under stress, especially when cortisol and adrenaline are high. Within 24 hours, your recall begins to distort. That's why one want safe, you should write or voice record every detail: time, date, officer names, badge numbers, what they said, and your exact distance. This becomes secondary evidence if your footage is challenged or lost. Courts treat contemporaneous notes as credible supplementary evidence because they demonstrate immediate recollection, untainted by hindsight bias. Finally, the 10th tip: file a complaint or consult a lawyer if your rights were violated. Too many people stop at outrage, but official records, internal affairs complaints, public records requests, or civil rights claims create the accountability system that ensures your footage means something. When a department sees patterns of unlawful interference with recordings, civil liberties groups can use that record to push policy reform. That's how single moments of resistance evolve into systemic change. So to recap the physiological and legal principles at play here, when your body feels fear, your heart rate accelerates, your focus narrows, your reasoning drops. That's biology, trying to protect you, but it can also make you impulsive. The solution is trained calm. Breathing control, deliberate speech, non-threatening posture. You're signaling compliance while holding the line of your rights. Legally, your First Amendment protection stands as long as you don't interfere. Your Fourth Amendment protects against seizure, and your due process rights ensure remedy if violated. Combine those with controlled demeanor, and you have something most people never achieve in these moments: calm power under pressure. That's the foundation. In the next segment, we'll go deeper into tactical responses, how to use state-specific language, the legal doctrine behind lawful orders, and the psychological techniques to diffuse confrontation before it turns hostile. Tactical responses and state-specific strategies. Let's go deeper. Once you understand your physiological and legal foundation, the next layer is tactical. How to apply this knowledge in real time, depending on your state, your surroundings, and the specific behavior of the officers involved. Because the truth is, knowing your rights is one thing. Knowing how to assert them effectively in the field is another. The difference lies in language, precision, and timing. When a cop tells you to stop filming, you're not just dealing with one law, you're standing at the intersection of constitutional, statutory, and case law. Federal courts protect your right to record, but states and municipalities can interpret reasonable restrictions differently. That's why understanding how your jurisdiction treats public recording is crucial. For instance, if you live in a state within the 1st, 7th, 9th, or 11th Circuit, your right to record the police in public is explicitly recognized. But if you're in the 8th Circuit, like Missouri or Iowa, the case law is less defined, and officers sometimes exploit that ambiguity to suppress recordings. So your first move is knowledge. Know your state's precedents. You don't need to memorize case citations. Just remember your constitutional base and your conduct principles: distance, calm, compliance, and documentation. Let's break down some of the most critical scenarios. An officer might approach and say, "I'm giving you a lawful order. Stop recording." That phrase sounds absolute, but lawful order is only legitimate when based on necessity, not convenience. A lawful order must meet 3 conditions. It must be issued by a recognized authority, the officer, be grounded in a legitimate government purpose, safety, investigation, or order, and be proportionate to the situation. If you're standing quietly on a public sidewalk, your recording poses no threat or interference. Therefore, the order to stop filming is not lawful, regardless of tone or repetition. Your correct response is not defiance, it's documentation. Keep recording and state clearly, "Officer, I'm not interfering. I believe I have the right to record from a safe distance." If they escalate, you maintain composure. Do not debate. Every extra word adds risk. The body language remains the same, still balanced and respectful. That balance between verbal assertion and physical restraint is what courts later interpret as non-confrontational conduct. If you're arrested afterward, your attorney can argue retaliatory arrest under the First Amendment, as long as your footage and conduct show you posed no actual obstruction. That's why tone and distance matter more than words. Judges evaluate context, and footage doesn't lie. This is one of the most common tactics. Officers will say, "You're making us nervous," or "You're putting yourself in danger." These statements sound protective, but they're often strategic. They introduce the appearance of safety justification, giving the officer legal cover to restrict your actions. Here's the physiological reality. Police training conditions officers to associate unexpected hand movements, rapid approach, or peripheral distractions as potential threats. If your phone is moving erratically or you step closer while filming, you're feeding their fear response loop. The optic system processes lateral motion faster than verbal cues, so movement will trigger defensive reactions before your words even register. That's why you anchor your body in camera. Plant your feet shoulder width apart, hold the phone steady at chest height, and minimize gestures. The smaller your motion signature, the less threatening you appear. If they say, "You're making me nervous," your answer should be calm and precise. "I understand. I'll stay right here and keep my hands remains visible. That sentence disarms tension through acknowledgement without surrendering your right. And legally, it's flawless. You're not arguing safety, you're affirming it. The footage shows you cooperating while preserving your role as a neutral observer. When multiple officers issue collective commands, stop filming, or phones down, the temptation is to challenge them en masse. Don't. The safest move is individual assertion with visible compliance cues. Back away, face the officers, and maintain the recording. Speak loud enough for the audio to capture your statement. I'm moving back as ordered, and I'm recording for accountability. That one line accomplishes 4 legal protections at once. It proves non-obstruction, it identifies your purpose as civic oversight, it establishes context for distance, and it captures real-time compliance. If officers still target you, the footage will show they knowingly interfered despite your obedience. That's what civil rights lawyers call willful suppression, and it carries weight in federal suits. Now, you may wonder, what if I'm detained just for filming? Detention requires reasonable suspicion of a crime. Filming alone does not meet that threshold. If detained, remain polite but firm. Am I being detained, or am I free to go? This question forces the officer to clarify their authority. If they say, "You're detained," ask, "For what specific offense?" Do not resist, just ask. If they can't articulate a lawful reason, they're outside their authority. The moment you show calm, legal literacy, you shift the psychological balance. Officers often back down when they realize they're dealing with someone who understands the rules. This one's tricky. If you're the subject of a stop, you still have the right to record, but you must balance that with officer perception. Keep your phone mounted, not handheld. Any sudden movement toward your pocket can trigger a use of force escalation, so mount the phone before the officer approaches. Start recording early, announce your actions. I'm reaching for my phone to start recording for my safety. That single statement informs the officer, documents consent withdrawal for searches, and shows transparency. If they say, "Turn that off," respond, "Officer, I'm recording for both our protection." That language frames the action as mutual safety, not defiance. Courts appreciate phrasing that indicates cooperative intent. It lowers perceived hostility and builds your credibility if the footage ever reaches trial. If they persist, and you're ordered to stop recording under threat of arrest, obey temporarily, but state your objection. "I'm complying under protest." That line preserves your legal objection and creates a record that you did not consent voluntarily. Later, your attorney can use that statement to argue coercion under color of authority. Sometimes police will claim your filming distracts bystanders or creates a crowd. If that happens, physically reposition yourself. Step aside, narrate it. "I'm moving away from others for safety." This shows immediate compliance while undermining their stated justification. The reason this is effective is legal psychology. Judges interpret visible adaptation as proof of intent to comply. Intent matters deeply in civil rights cases. If you sense escalation, activate a live backup or cloud sync. The moment the footage is uploaded, its destruction becomes futile. Even if they take your phone, your evidence survives. Always remember, your goal isn't to win the argument. It's to survive the encounter with your evidence intact. Now let's address what happens internally in both bodies, yours and theirs, during this power exchange. When you assert your rights calmly, your tone and pacing influence mirror neurons in the officer's brain. Their nervous system subconsciously begins to sync with yours, reducing tension. This phenomenon is called physiological co-regulation. It's why trained negotiators speak slowly and avoid abrupt movements. You can use the same technique. Keep a slow rhythm in speech, measured pauses between words. It subconsciously signals control and reduces perceived threat. In legal confrontations, psychology is your shield. People who escalate emotionally feed into the stereotype of aggression. People who speak slowly and deliberately appear credible and non-threatening. In every courtroom, demeanor counts as much as evidence. Remember that. Now, some officers may still violate your rights regardless. The reality is that body cameras and training don't erase misconduct. That's where your next layer of protection comes in. Post-incident legal action. Immediately after any confrontation, file a public records request for the officer's body cam and incident report. Under the Freedom of Information Act, or state equivalents, you're entitled to obtain those materials unless they're part of an active investigation. Having your own footage synced with official reports gives your attorney leverage to identify inconsistencies. For instance, if the officer's report claims you interfered, but your video shows you standing calmly 20 feet away, that's a constitutional violation. Also, document everything sensory: how the officer spoke, their tone, any commands, even ambient sounds. The human body encodes emotional intensity as memory anchors. The more detail you record early, the more credible your later testimony will be. If your phone was confiscated or broken, request a preservation letter through your attorney to the Department department. This prevents them from deleting data or altering evidence. Chain of custody documentation is critical. Without it, departments may lose evidence. Next, learn the difference between internal complaints and civil suits. Internal complaints are administrative. They rarely yield punishment but create a record. Civil rights suits under Section 1983 target constitutional violations directly. You can sue for damages if an officer unlawfully detained, seized, or assaulted you for filming. The key phrase your attorney will look for is retaliation under color of law. That's legal language meaning the officer used government authority to suppress a constitutional right. But here's the nuance. These cases often hinge on qualified immunity, a doctrine shielding officers from liability unless they violated clearly established rights. That's why your conduct during the recording matters. If your behavior fits within what courts recognize as protected, calm, distant, non-interfering, then immunity collapses. Your precision becomes your leverage. Let's now discuss multi-officer encounters. When multiple cops approach you, your instinct may be to engage all of them verbally. Don't. Pick one, the one speaking directly to you, and keep focus there. Peripheral scanning can be misinterpreted as agitation. Maintain soft eye contact with the lead officer. Acknowledge the others with brief glances, but don't divide your attention. This demonstrates control and situational awareness. Lawyers call this narrowing the field. Psychologically, it reduces perceived unpredictability and limits escalation risk. Also, always check your state's wiretapping laws. While most allow public recording, a few, like Maryland or Illinois, use to interpret two-party consent more strictly. Thankfully, modern rulings have clarified that public police encounters are not private communications. Still, if you're in a gray area state, announce you're recording verbally. You're being recorded for transparency. That verbal notice satisfies even the strictest consent standards. Now let's talk about strategic backup. When possible, designate a secondary recorder, someone else filming you filming. This provides corroboration if your footage is seized or edited. Encourage them to stand farther back so they can capture your entire posture and interaction. This triangulation of perspectives mirrors evidentiary redundancy in law enforcement itself. Multiple body cams, dash cams, and witnesses. Redundancy protects truth. And speaking of truth, let's address one final misconception. Officers saying, "You can't post that video online. It's evidence." That's false. You own the copyright to your footage unless it's under court order. However, posting it before legal proceedings can sometimes complicate discovery, so if your goal is justice, not virality, consult counsel before publishing. Evidence first, exposure later. To conclude this segment, let's connect the dots between physiology, law, and behavior. When an officer tells you to stop filming, you face three simultaneous battles. One physiological, one psychological, one legal. Your body wants to react, your ego wants to defend, but your brain and your rights demand restraint. Calm assertion backed by legal literacy is the single most powerful combination in these encounters. In the final part, we'll cover your post-incident roadmap, how to file formal complaints, protect digital evidence, and use your footage strategically in court or public advocacy without compromising your safety or credibility. After the encounter, protecting evidence and pursuing justice. Once the encounter ends, the real work begins. Because what happens after the officer tells you to stop filming can determine whether justice is served or whether the footage disappears into silence. This is where knowledge turns into power. The aftermath is your time to act strategically, not emotionally. Every step you take should be deliberate, methodical, and supported by evidence law and civil rights procedure. The first and most urgent step is securing your footage. Immediately back up everything to at least two separate locations, a cloud service and a local drive. Use encrypted storage if possible. Unedited footage carries more legal weight because it maintains an unbroken chain of authenticity. Courts look for metadata integrity, timestamps, GPS location, and file size. Editing or trimming before backup can weaken that chain. Keep the raw version untouched. Create a duplicate for sharing or posting if necessary, but always store the original offline or in secure cloud storage. If your footage includes sound, note whether your jurisdiction recognizes expectation of privacy. In nearly all states, police and public have no such expectation, but recording unrelated bystanders could raise privacy questions in civil court. When sharing online, blur faces of uninvolved individuals or minors. You're protecting yourself from claims of harassment or defamation while keeping the focus on government conduct. Next, document your memory while it's still fresh. Within 12-24 hours, write down or voice record everything you remember: time, date, location, officer names, badge numbers, exact words used, and physical distance. Stress distorts memory because cortisol interferes with hippocampal encoding. The longer you wait, wait, the more your mind fills gaps with approximations. A detailed account written immediately after the incident can later serve as corroborative evidence. Lawyers use these statements to reinforce your testimony's credibility because they demonstrate contemporaneous recollection, something fabricated stories rarely show. If officers confiscated or damaged your phone, contact a civil rights attorney or legal aid group immediately. The American Civil Liberties Union, ACLU, and similar organizations maintain hotlines specifically for these cases. Provide them your written notes and any witness contact information. The legal claim likely falls under 42 U.S.C. paragraph 1983, a federal statute that allows individuals to sue government officials for violations of constitutional rights. The focus of such cases is whether the officer acted under color of law to suppress protected activity. In this case, your First Amendment right to record and your Fourth Amendment protection against unreasonable seizure. Your attorney will issue a litigation hold letter, sometimes called a preservation letter, to the police department. This formal notice compels them to retain all related evidence: body cam footage, radio communications, dispatch logs, and reports. Destroying or losing evidence after receiving such a letter can amount to spoliation, a serious legal offense that can cripple the defense in court. That's why time matters. Send the notice within days, not weeks. Next, file a public records request. Under federal and state freedom of information laws, you can request materials such as police reports, 911 call logs, or body camera footage. The process varies by jurisdiction. Some require online forms, others formal letters, but the principle is the same. You're demanding transparency. When filling the request, use exact details: date, time, location, and officer identifiers. The narrower and more specific your request, the harder it is for departments to delay or deny. If your footage shows excessive force, intimidation, or unlawful seizure, your attorney might also notify the Department of Justice's Civil Rights Division. Repeated complaints against the same department can trigger federal oversight or pattern and practice investigations. Individual complaints may seem small, but together they form the legal basis for systemic reform. Now let's talk about how to file an internal complaint. Internal Affairs, IA, complaints are administrative, not criminal, but they create an essential paper trail. Keep your tone factual and professional. Avoid speculation. Just state the facts, reference the incident number if available, and include copies of any footage or witness statements. Submit through official channels, not social media. Departments often dismiss online posts as informal reports. Once submitted, request a written acknowledgement of receipt. If they fail to respond within the stated time frame, usually 30 days, follow up in writing. Persistence is key. Bureaucracies rely on public fatigue to bury complaints. Don't let that happen. Parallel to these steps, understand the psychological aftermath. Encounters with police authority can leave lasting anxiety, even trauma. The human nervous system doesn't distinguish between physical threat and perceived coercion. Both trigger the same stress hormones. Your amygdala may stay hyperactive for days, causing insomnia or intrusive memories. Recognize this not as weakness, but as biology. Engage grounding techniques, controlled breathing, journaling, or speaking with a counselor. A regulated mind supports effective legal action. Let's turn now to building your legal case should you pursue a claim. Your attorney will need to establish 4 key elements. 1. You were engaged in constitutionally protected activity, filming in public. 2. The officer took adverse action against you, ordering you to stop, detaining, or seizing your device. 3. The officer's action was motivated or substantially caused by your recording. 4. The officer's conduct was not supported by legitimate safety or interference concerns. If these elements are proven, you may recover damages for emotional distress, property loss, or constitutional violations. However, your behavior during the incident can affect the outcome. Aggressive language, refusal to move when reasonably asked, or proximity that appears confrontational may give the defense leverage. That's why calm, consistent narration in your footage is invaluable. It reflects discipline under pressure. When preparing for court, your attorney will organize your materials into evidentiary categories. Primary evidence, the original video file with unaltered metadata. Secondary evidence, written notes, witness statements, photos of the scene, official records, police reports, dispatch logs, body cam footage. Expert testimony, legal or forensic experts who can verify distance, sound analysis, or officer protocol violations. In many cases, these suits don't go to trial. Departments settle quietly to avoid public scrutiny. Settlement negotiations can include financial compensation, policy changes, or disciplinary measures against officers. Even when outcomes are confidential, the process still matters. It pressures departments to retrain officers on public recording laws. But remember, justice isn't only about compensation, it's also about public accountability. If you choose to share your footage publicly, Do it strategically. Include factual context, date, time, and location. Avoid inflammatory captions that suggest motive or guilt. Let the footage speak. Emotional editing or sensational framing can backfire legally and politically. Truth, unembellished, is your greatest weapon. That brings us to the end of this video. For more interesting videos like this, click on the cards on your screen.